Now we turn the time over to today's presenters. Thank you.
Thank you, Marlene, and thank you everyone for joining us today for trauma-informed lawyering. I think it's a topic that all lawyers need to know, and even if you already know it, maybe this will be a nice refresher for you. Shelley, I changed my mind. We're going to introduce ourselves now. I'm Kelly Stoner. I've been with the Tribal Law and Policy Institute for over 13 years. I'm a lawyer, a former law professor at a University of North Dakota and law school in Oklahoma. I was a tribal judge for the Seminole Nation of Oklahoma for 8 years and currently am an associate justice for the MHA Nation Supreme Court. So that's me, but before I turn it over to Shelley, I think there's something you all should know. Shelley and I started out our careers working together, and we worked together for over 10 years for the Apache tribe of Oklahoma. I was her litigating attorney. She was my tribal victim advocate. And so we're going to be bringing some of our stories to you today, some of our experiences, wanting you to share your own experiences with us so we can learn from one another. And Shelley, I'll turn it over to you for you to intro yourself.
Good afternoon, everybody. It's so good to be here today. I am Shelley Miller. I am from Oklahoma. I am a Kiowa tribal member and have been an advocate for 20 plus years now and excited to be here still working with Miss Stoner. And I'm going to stay off camera today because I am on travel and actually in Wisconsin. So in order to get the best internet connection, I will stay off camera. Thank you. It's good to be here today.
Hey, Marlon, can we go to the next slide? Here's our disclaimer, and here we are, and here we go. The learning objectives today. By the end of the presentation, we're hoping you will be able to list different types of trauma responses, understand the impact of trauma on the attorney-client relationship, understand the benefits of trauma-informed legal practices. We're going to go back to a webinar, just briefly, to a webinar we did on privacy, confidentiality, and privilege, and just asking everybody to remember that protecting victim information is directly connected to victim safety. So we're going to touch on that just briefly. We'll discuss the 6 principles of trauma-informed legal representation and discuss strategies for implementing trauma-informed practices into your legal representation. I know we're not all lawyers here today, but in true law school form, we couldn't resist putting some hypotheticals in here for you all to discuss how you would handle them. Victim advocates, we want you to chime in too, because we learned from you. And so with that, let's move to the first slide, Marlon. Okay, we're going to start with some data. Again, these webinars are recorded, so you'll have this data available to you. 70% of U.S. adults have experienced a traumatic event at least once in their lifetime. A third of the population will experience severe trauma in their lives, and 6% of Americans have PTSD during their lifetime. I think this slide sums up that you should expect that all of the clients coming in have experienced trauma and may be experiencing trauma as they come into your office. So let's move on. This is what trauma-informed lawyering is, according to the pedagogy of trauma-informed lawyering. It's practices that require a lawyer to put the realities of the client's trauma experiences at the forefront of their representation. Not only that, but to adjust your approach to be informed by the client's trauma experience. If I were going to boil this all down, we're expecting the client is a victim of trauma, and we're watching, we're cueing in on behaviors, responses, and at all times, this may be hard for lawyers, but at all times, we are willing to adjust our representation based on the client's needs. So I want you to kind of pack that in there. That's where we're going with this today. Next slide. Shelley, I think
Our
this
trauma,
one's, oh yeah, sorry, I was turning it over to you.
thank you, Kelly. Our trauma responses come in many, many different forms. We would like to pull out four of those today. Our fight response is an aggressive or confrontational reaction, such as anger, irritability. Our victims may be having impulses to control the situations they're in or be defensive. Our flight is the urge to physically or psychologically escape, flee. The victim may be an overthinker, have anxiety, be a perfectionist, be in the state of a panic and constant fear. Freeze, a state of paralysis or being stuck, and victims may be disassociated, depressed, have difficulty making decisions, or maybe even sleeps a lot. Appease, people pleasing or appeasing behavior. Victims may have a fear of saying no and disconnect from their own body and their needs, and they feel responsible for others.
And I just want to add to this, this trauma response that we're talking about here today is when your brain takes over and you can't control it. Your brain is taking over. These are built in to your DNA. And so these aren't necessarily decisions that the client is making. Did I see a hand up? Thought I did.
I believe the hand was lowered, Kelly.
Okay, good. Okay, so here are like Shelley said, there may be others, but these are the four most usual trauma responses that you might see. Does anybody, I'll just ask this question. I know it's not on the deck. Does anybody out there know what your trauma response is? It could be something like, I'll give you my example. Snakes. I am so afraid of them, and I have a phobia of them. And even if I see one out in the driveway, which may be 60 yards away, I immediately run. I'm a runner. It's flight for me. Does anybody else have any idea?
I can
Fight?
verify
Oh, a
that
fighter. Yes,
Kelly is definitely a flight person.
I am a runner.
Yes, definitely.
Somebody else freezes. Okay. A flight, yes. Hello to you, my fellow runners out there. Yes. Can't stop it. It's taken over. Freeze, okay. Right. And some of you may not know, but you probably will end up knowing because we all have some sort of trauma or scary event where our brain takes over. Um, Fight, defensive. Okay. Okay. Oh, phobia of elevators. Okay. Yes. Okay, good. Well, so then you all kind of know what we're talking about. And these are, again, built in. The brain's gonna take over, and these may be some of the responses. Let's go to the next slide, Marlon. Let's talk for a moment. Why is this topic important? The impact of trauma on your legal representation, on your ability to achieve your client's objectives. You should know that trauma, depending on what kind it is, and especially in the domestic violence world, our clients are coming in with a lack of trust in lawyers. They may not have wanted, this might be their last resort to try and address the situation. Lawyers sometimes get a bad rap. So just know that you're going to have to start to build trust, especially In cases where we have sexual violence, the client's going to have to share intimate details with you. Um, Lack of engagement in the case. If your client doesn't trust you, they are not going to give you all the information. It's going to be very difficult for you to plan your legal strategy. And Shelley, once I get through these, I'm going to come over to you to see if you have any comments. Inability to recount events, memory loss, and gaps. This is a huge one because as lawyers, we need facts. We need the story, but that story may not be coming back to the victim, the trauma victim, in sequence. It may be bits, it may be pieces. They may have memory gaps and the memory comes back later. So all of these are things we're going to have to deal with in our legal representation. Difficulty processing information. This is a huge one. When you're doing your interview with the client, not only may there be a lack of distrust and they're having some memory issues, but anything you tell them they may not remember, or they may remember only bits and pieces. We're going to talk about some tips for interviewing later, but just see what a mountain we're up against here. As it's not a law school hypothetical. We can't just get the facts and go. The facts may come to us in bits and pieces. There may be challenges in communication because of those memory deficits. And also, if you're representing a native client, their English may be their second language. So we're going to be mindful of that. We're also going to be very mindful of the increased amount of time we need to meet with that client to prepare for the case. We may have to do several shorter interviews. So just keeping that in mind. And the client in severe trauma cases, the client may have a limited ability to even participate. They may not even be ready, capable of going into court and speaking coherently and having their memory come back to them. Court can be a very scary place. Shelley, do you have anything you want to add to that?
I think all of these are good reasons to work with your advocates. Your advocates can help with every one of these, help with the trust that you need in an attorney. They can help you with memory lapse and gaps of information because that advocate has already talked with that client and built a rapport with them and has the ability to say, oh, but did you remember this event? Or you really need to speak more on this topic with the attorney. They can also help with those challenges of communication, processing that information, and also helping them to remember what that attorney said. Because sometimes when a victim is going through and the attorney's talking to them, they start reliving that situation instead of hearing what you are saying. And so they're not listening actively at that point in time. And then by the time that they come back to that reality, they have missed some of the information you're trying to give them. So if that advocate is working with them and you're telling that advocate, I need her to bring back a copy of her protective order that she's already filed, the victim doesn't remember that, but the advocate does, then she can help her remember to get that back to you within the next couple of days. So all good reasons to work with an advocate.
Great point. Okay, let's move to the next slide. These are some of the benefits of trauma-informed legal representation. Enhanced safety. Do you want to say anything about that, Shelley?
Safety is the most important thing whenever we're talking about domestic violence and sexual assault cases. It is at the forefront of advocacy. Should be always at the forefront of all the representation that you do for a domestic violence victim, especially whenever that safety is when your representation is on the line too, because sometimes that safety issue is about your representation. Many times attorneys are confronted, so safety has to be at the forefront of everything you do for domestic violence victims.
And let's not forget about safety. For me, for the lawyer, getting into the courthouse and out of the courthouse. Safety while you're inside the courthouse, where everyone's going to sit. That these little things, these little maneuvers that you can take that enhance safety will make the client feel more comfortable. Also, there will be increased trust and rapport. Again, you're going to have to build it. Most likely, it's not going to come easy. Shelley, do you have any? Well, I know we're going to talk about how to make the interview room a friendlier place for victims of trauma. Do you have anything to say about how attorneys can increase the trust with their client?
Listening is a big point, especially whenever victims are coming in, because sometimes they don't have that person who is listening to them as much as other people. And so, in order to get that trust and that rapport with them, just listening to the story and saying, okay, this is how I can help you is a big deal for them.
Thank you. It avoids re-traumatization because already coming into this, we are aware that this person has been under some level of trauma and may be experiencing trauma still. And coming into our office may be traumatic for them. So we're gonna be mindful of that. And it assists us in obtaining the information we need as lawyers to help the client reach their goals. So that's the kind of representation that I'd love to see everybody provide to their trauma clients. Shelley?
Empowerment and that support is so important for that trauma-informed legal representation that I just can't say enough about that. Their voice and their choice is very important, especially in a domestic violence case, because a lot of their voice and their choices have been taken from them. So giving them that empowerment back, their ability to make those choices going forward is very important.
I think that's sometimes really hard for lawyers to do. If y'all remember back to law school, I mean, really kind of the overtone of it is you need to win your case. And you may have one strategy that you think makes it a winner, but the client may have another strategy and she may perceive winning in a very different way. So we're going to have to open our minds as we move through this and really work to empower that client and build that trust with the client. And again, because trauma affects memory, we're going to keep coming back to revisit the client's objectives because they may change during the legal representation. Next slide. Okay, we're up to our first hypothetical. I know everybody's excited about this. This is the way we want to set this up. We want you to put your thoughts in the chat. I'm going to read it to you. It'll have a particular question. Marlon may even put a prompt in the chat for those of you who don't want to read the whole thing and you're in a hurry. All right. The attorney is meeting the client for the first time. When the attorney goes into the waiting room to get the client has brought her pastor with her. The client and the pastor both stand up to go into the attorney's office, and the attorney says, oh no, he can't come in here with you. Discuss that response and what would you do in this situation? I'll give everybody a few minutes to type.
What would you do in this situation as an attorney? And what would you
Yes,
do in this
or an
situation as an
advocate.
advocate?
Thank you, Shelley. We can
Yes,
do
for both.
attorneys and advocates here. Okay. I see Chantel. Um, okay. It's not just about winning, but ongoing safety and recovery. A better response would be for the attorney to bring them both into the office, meet them, understand their relationship, and then explain the attorney-client privilege. Okay, I like that. The response takes away. Oh, I can't keep up with all these. Thank you all for putting these all in here. Hang on. Okay. Explain why you're happy to have the person come in, but it may limit some of the things we can talk about. The response is reasonable if the lawyer's worried about confidentiality. Spoken like a true lawyer there. We're gonna come back to that one, but it may make the survivor feel less safe. Might it also impair the ability to remember things if she doesn't feel safe? I would draft a release of information, have the pastor sign it, then confirm with the client in private whether she wants these are great responses, whether she wants the pastor to be there. The attorney should have explained the attorney-client privilege and how a third party affects it, and sign a release of information. Do whatever the client makes the client feel safest. Okay, and then we have, as an attorney, I would bring them in and explain confidentiality, draft a release of information if the client wants to have the pastor with her. I think all of those are very good responses. As you all can tell, I don't know if any of you were advocates. If you want to chime in here on how you think this should be handled, but I can tell you right now, the lawyers are worried. And they're worried about the attorney-client privilege. It'll be on the next slide, but we can stay on this one. That is the privilege that protects that communication between the lawyer and the client. It's protected by law. When you bring a third party into the interview room, in most instances, it pierces that. And what that means is now defense attorney can subpoena the client and the pastor and ask them what was said in the interview room. That attorney-client privilege may have been compromised. And that's why you see all these attorneys saying, we want to do a release of information. We want to make sure the client knows the risks involved of bringing the pastor in. It needs to be explained very carefully. I myself, as an attorney, might want the client to sign that a release saying she understands the possible ramifications of having a third party in the room. But let me tell you this, I don't think in my legal law school career, it was really stressed that the client owns the privilege. The client can decide who needs to be in the room and who doesn't. It's the lawyer's role to explain the consequences of having that third party in the room. And I can also tell you, and Miss Shelley Miller and I handled the case years ago, the client had been cognitively impaired due to physical injuries at the hands of the perpetrator. She had brain damage. And so her ability to keep information organized and provide information was greatly compromised, and she had what was called an exaggerated response. Someone knocked at the door, she jumps up, she doesn't scream, but she's clearly flustered. She goes and begins digging in boxes of evidence that she brought in, and she needed a third party, her advocate, in that room for me to be able to interview her. So I carefully documented that in my notes so that if there was any issue about whether that attorney-client privilege had been pierced, I had notes. And ethically, it was permissible for me to have someone in that room with her because she could not answer my questions after the knock on the door. She totally lost her focus. So I'd ask you to remember all those things. Shelley, what do you want to add to that?
I think one of the responses from Brooke says that it takes away the client's safe person, and I agree with that. There are many reasons why a victim might want a third party in there. Um, but with this scenario, I kind of have a question. Does the pastor not have the ability to have the privilege too, or is that not,
No,
he doesn't?
it's only the
So
client. Yeah.
so as an advocate, I'm automatically thinking about the safety. I want their safe person to be there, no matter who that is. But I also want that attorney to explain why.
Mhm.
Because a lot of times victims have never gone through this process before. And so if they understand that and they're like, okay, I get it, I'll go in by myself, or no, I still need my support person, then I want them to have that support person because it's important for them to move forward. And if you don't have that support person in there, you're not going to get the same collaboration or success as you would if you have them go in individually. So I just think there's a lot to that and want to make sure that as we're going through and remembering all those trauma responses, that there are tons of different reasons why they may need that support person in there. For whatever that reason is, that I would want that client to have the ability to make that decision going forward.
And many, many times this third party will be the advocate, the victim advocate that they want to have in there. So I do want you to remember, though, that the victim, the client owns this privilege and the client can waive it. The client can sign a release. And I think that's a good practice for lawyers to have those releases in place where you have explained it. And remember this, when you explain it, the trauma may keep half of the information from sinking in. So you might want to explain it and then say, do you have any questions about it? So that you tell me what you think, what you think I said? Let's make sure we've got a good understanding here, because this can be potentially, if it's not done correctly, a legal malpractice issue for the lawyer. If the lawyer didn't explain and that privilege is pierced and all of the information comes flowing out. So you want to make sure you're protecting yourself. You're going to remember this belongs to the client. And whether you agree or disagree, lawyer, the client gets to make this choice.
And there are many places where advocates have that privilege too. So I wanted to make sure that everybody kind of understood that too. Is sometimes advocates also have that ability to be able to be in the room and be protected as well from the information that they are hearing and gathering.
And so in the chat, you'll see the advocate speaking up saying, I would have explained this in the beginning, especially if the advocate's used to working with a certain group of attorneys, to know that the lawyer may ask you, if you insist on having the third party in, that there will be a release of information. And Jerry points out that in some states, the advocate might be covered by a privilege, but if you're in tribal court, those state court privileges may not transfer. So if you're in tribal court, in Indian country, you're going to have to see if there's an advocate client relationship. Some tribes have them, some tribes don't. So we want to make sure, and remember, I mean, this is way down in the weeds. I might not even need to tell you this, but it's the level of privilege. Like if the attorney-client privilege is almost absolute, there are only certain specific things that happen where we can release the information without the client's consent. The victim advocate client relationships, I've seen some tribal codes that make those absolute. Some will say only unless there's a criminal case uh, pending, things like that. So you want to just make sure you're checking all of those privileged statutes there so that we don't run into a situation where uh, the advocate and the attorney don't share the same level of privilege. So we're going to be in litigation over that, I think. Any other comments on this before we move? We have several hypotheticals. We wanted to get your brains warmed up.
There is one
Okay.
more question, and it
Okay.
says, If that's the case, is it the same for when the client brings them to apply for the domestic violence program? Is it allowable with the release of information form?
Okay. I'm not sure I understand that. If I'm thinking you're meaning if the state has the victim counselor privilege and you're in state court, um, I might need some help. Carmen, can you help me with that question? Can we unmute her and let her talk or?
I'm wondering if she's talking about it from a programmatic perspective. So if somebody comes to the DV program and brings a third party, is it the same?
It's the same, unless there's a privilege. And it matters where we are in state court or tribal court. In tribal court, we're going to follow tribal statutes with respect to that advocate client privilege. Carmen, did we get that right? I can see you're unmuted.
If she typed in yes.
Yeah. Jerry, I agree with you. It is. And when you bring that third party in, uh, it's arguably waived, but that's okay because client, if that's what the client wants to do, that's what should happen. The attorney needs to protect themselves with a release of information or something along those lines. Yes, it is. You are exactly right, Jerry. Okay, Carmen said, I think we got it right. So it can be a confusing area. It can be a confusing area of the law. And I will tell you, in Indian country, when Shelley and I were working together, it is not uncommon for an auntie to show up, a best friend to show up, a pastor to show up. So get this in order before you run into it. Have your release ready. And you can ask the pastor to step out while you explain the release, uh, that sort of thing. But if that's the client's choice and she wants the pastor in there, that's her decision to make. Lawyers don't get to make that decision. Okay, let's go to the next slide. And this was just a slide to remind you, in the previous webinar, we went over all these concepts. And in that fact pattern, we're going to be concerned about the privilege and waiving the privilege. And it really doesn't go in right here, but remember, your client can waive the privilege in many ways: putting it on Facebook, uh, letting other people know what you said, things like that. So let's go to the next slide. Okay, Shelley, you want to do this one?
The attorney is representing a client in a child support matter, and there is a hearing scheduled for tomorrow. Despite numerous requests and reminders, the client has still not produced the necessary documents. The attorney leaves client a frustrated voicemail. What would you do in this situation? I think this is a good place to bring up again working with an advocate, because if you're having trouble getting information from your client, your advocate can also help contact and say, hey, they really need this and this is why. And that way you have another person who's helping try to gather that information. The advocate also has the ability to probably make in-person contact faster and quicker, especially if they're in that neighborhood. So working with that advocate is, I think, extremely important and can be very helpful.
Okay, so thank you, Shelley. I see communicate to the client what the attorney needs. That's a good idea, but remember, the client may not be absorbing the information. Shelley, what might be going on in that client's life that would keep her from getting the documents to the attorney?
Tons of different things can be happening. And I think as an advocate, you visit with your clients as much as possible. You check in, you make sure they have all the right resources. Some of that can be a trauma response where they're just disengaging. It's not that it's not important, it's that they are not functioning at that moment in time. Unfortunately, whenever you're going through a lot of trauma responses, there are a lot of different things to consider, especially when it's a DV victim. Safety could be an issue with that. They might not have the ability to get those papers immediately. That she may have been told. It may be a situation where she's like, if I go through with this child support matter, then I'm going to have other consequences happen with my perpetrator. I mean, there are all kinds of things that could be going through her mind at that point in time. So just making sure that you have patience during this frustrated time is important, and to remember that there are trauma things happening, but also safety issues could be a big part of why she's not responding.
Thanks for that, Shelley. I see a lot saying get your advocate to help you. I think Jerry says, I've been here. I use every avenue available to facilitate contact, advocate, relative, friend, employer. Also, Chantel, this is one of the things that came to my mind. She may need a ride. Uh, her phone might be down, her internet might be down. The client may be in flight mode. Let's see, I think the client may have so much on their plate that is highly likely that surviving is the most important thing. I think the piece of this knowledge check that I find concerning, and I won't say that I haven't been here myself. We're all busy, lawyers are busy, we're asking, there's a hearing coming up, is that frustrated voicemail. I think, again, we need to know, is that a safe place to leave a voicemail? And if it is, can we just be patient? Can we be empathetic? Can we remind her that if the hearing is in 2 days and if we can't get the documents, uh, there might be consequences and this might be it, but that you're willing to continue the representation, do the best you can. I think it's that frustrated voicemail that sticks out to me. Yeah, there may be no money to pay for a document. Yeah, I think all of those things, empathy, 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 and you're going to have to override your law school installation that you need to win, 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 or the judge is going to chew on you if you don't have these documents. It's her case. It's her case. And if you can't get a continuance, we're going to proceed on as best we can. Yeah, let's see. Chloe says, I think also watching the passive aggression with this, it can make the client not want to pursue the case anymore. It can. Clients get so tired and fatigued with all of it. Ask a legal assistant new to this space. What point can you decide you can't work with the client? You're always going to have to know that. You need to get that straight first, because if you're going to work in this field, you are going to have people who are suffering from trauma. Yes, and Shelley and I work on the Circle project the NAV has, where we pair attorneys with advocates to represent civil cases and victims' rights. And it's not always an easy match, an easy mix. So we spend a lot of time talking between the advocates and the attorneys about how to best handle these kinds of situations. And Shelley, I don't remember how many years we've been going, but maybe only twice have we had our attorneys pull out. Would you say that's a fair estimate? And usually it's because of something ethical.
Yeah, normally our attorneys aren't pulling out unless it's an ethical situation. They try to be as patient as possible. I think one of the things, going back to the frustrated voicemail, is if her trigger point is being yelled at and that attorney has yelled at her, then she's being re-victimized. And so I want us to remember that our actions can also spin her into that situation where she's like, oh my gosh, I can't handle this. I can't do anymore. And it really shuts her down. Um, I think it's a fine line between trying to navigate through that trauma and how to help her recognize some of that trauma. And as an advocate, help her get resources to help her work through some of that, so that it's easier to work in those particular situations. An advocate can really help with a lot of those, finding resources for her to help her through navigate through a lot of those situations.
I think if I were the attorney in this case, I would pivot and call that advocate and explain, I've tried, I need help. We have a hearing coming. Can you help me? Because overwhelmingly, my history with advocates has been they're always willing to help. They want to help the client. Okay, let's go to the next. Okay, I don't want to wear y'all out with these. I think this might be the last one. Knowledge check again. Attorney arrives at the courthouse for a hearing on custody and child support involving domestic violence. Client informs the attorney at the courthouse that she has dropped the protection order and is considering reconciling with the defendant, and you are ready for trial. What would you do? Okay, good. Chloe says she wants to ask, is this something the client's doing willingly or if they're being forced? So that's good. Because I think you're going to try to get at the gist of that. Is this her decision? Is somebody putting pressure on her? Um, yeah, keep going and typing so that we can get our discussion going. I think it depends on the state. If the state is pressing charges with DV, okay. More information. Again, why? Try not to show judgment. That's great. Discuss potential outcomes. That's our job. We're going to say, if you choose this, then these might be the consequences. If you choose this, then these might be the consequences. Jerry says, I'd ask why she dropped the PO and what happened to make her consider reconciling. Okay, good. Discuss the pros and cons. I love that. Reassure them that you will still be there. Your door is open, even if they want to dismiss the case, which sometimes it's difficult to do when you're ready for trial and you put all the hours in, but it's the right thing to do. Get them in a safe place alone. Spend some safety planning. Yes, and I would be calling an advocate in to help me with that for sure. And if the state is pressing charges, asking client more about how we can support and explain, the state will move forward anyway. If there's a criminal DV charge against the perpetrator, request a recess. This always comes to my mind too, Chelsea. Request a recess, discuss the decision. And again, I think the danger, the safety, just discuss it. Make sure she can repeat back to you those options you've discussed. And if that's her choice, then that's where we leave it. Okay, but I always think about getting a recess too to give her some time because we all know in domestic violence cases, it's about power and control, and the perpetrator's going to be trying to get that control back. So if we can give her some space, give her some time, she might change her mind. She might not. Shelley, what do you want to say about this one?
Oh man, it's a really tough one, I think, especially when they've dropped that protective order and everything you've worked for in the past month or so, several months is gone. Um, But as an advocate, that educational piece and always reaffirming we're here if you need us is very important. I think empowerment for her and that voice and that choice is extremely important. Making sure they understand, all of the pros and cons of their decisions and keeping them at the forefront of everything that we're doing, including their safety as always important. So just all of those things come to mind. It is not the easiest situation, but I think patience most of all, because a lot of times, I mean, this sounds like it's final. We're going through the final pieces of everything, and that's scary for anyone making changes in their life. So I think it's just there's a lot of pieces to consider with this, and most of all, just making sure that we ourselves know our appropriate responses and how trauma may be implied in this and how it's impacting her choices and her decisions. And that we also understand that at the end of the day, we all get to go home and she's the one who has to live with her decision. So we also want her to understand that and that she has all of the support she needs, whether it be advocacy, whether it be the attorneys, whether it be DV programs, any of those things that we are here for her.
Thank you, Shelley. I also see Jamie makes a point. If this were a criminal no contact, if there was a criminal case, the perp's charged with domestic violence, might there be a no contact order in there? And there very well could be. In some states, it's mandatory. In some tribal courts, it's mandatory. But I always tell folks, while a no contact order might qualify as a protection order, it's most likely not going to be entitled to full faith and credit as they cross jurisdictional boundaries. And it most likely will expire if there's a plea agreement or there's an adjudication. So it is a temporary, but usually those no contact orders are going to have provisions, stay away provisions in them. So that's something you certainly would want to check. Jerry says I would advise her to go through with the hearing since she's only considering reconciliation. She can always decide after the hearing, and that would be up to her. I mean, I don't see a problem with you making that suggestion, but also telling her if you want to dismiss today, I will do that for you. There are some consequences to that, though, right, Jerry? I don't know how many judges are hearing these kinds of cases. If you're in a rural area, if you're in a tribal court, that the next time they come around, the judge might not be so friendly to the case. So all of these unwritten things, but hopefully you're going to have that advocate right there with you, and she's going to be explaining, and you're going to be double checking for understanding. Yeah.
And
Okay, good.
keep safety at the top of that. There may be reasons why she's saying, no,
Oh,
I don't
yeah.
want to go through this because of safety issues. So always, always, always consider those safety issues first.
Yes. Always consider safety issues regarding the perpetrator and or the perpetrator's family, because that can all come into play in the safety planning. Okay, let's go to the next slide. Great job, everybody. Great job. I love those answers. All right, 6 trauma principles that are related to trauma-informed representation. You can see the citation down there. Believe it or not, there were not a lot of resources on this topic. I think we gave you almost every one we could find. Marlon will talk to you about those resources later, but I agree with these. This is why I think they're so good. Transparency. This to me are those options we were talking about giving that client later, whether it's about waiving the privilege, whether it's about wanting to dismiss the case. We're transparent. You're always going to be welcome here. You can come back here later. There may be consequences, but you can come back. And also telling that client the consequences of her decision. Be credible, be forthright, be non-judgmental, be empathetic, but hopefully that client will throughout this process become very educated on the consequences. Even if the client changes their mind later and it's difficult for you to maneuver your legal strategy, she'll see you working for her, and that what she has to say is important. She's the captain of this ship, and she's understanding those consequences and still wants to do it. Predictability, she needs to be able to, that we're predictable. If we set an appointment, we're going to be there. If we tell her one thing, that's what's going to happen. I will never forget, I had a client who, we had done all the interviews. We had the advocate. She was under severe trauma, and she didn't want to talk to me about her drug usage that he used as a power and control mechanism. He was on them too. And I told her, I advise that we bring this out first thing, because that's the first thing he's going to ask you about on cross. And we talked about it. We worked through it. She was being proactive and doing outpatient therapy. And so when she gets up on the stand on cross, well, no, we brought it out first. We brought it out with her permission. And it was like an eye-opening thing to her, because it was the first thing they wanted to talk about on cross. So she was like, "You're predictable. You told me this would happen. You said this was one of the things that would happen, and if I didn't get proactive to keep custody of my children." So being predictable. Client control, another thing I'm not sure they teach in law school very well, unless they've started doing that recently. The client is in control. We don't just get a fact pattern and we pull those elements out and we say, "Here's all the evidence we have, we win," if that's not what the client is wanting us to do. We're reliable. We do what we say. We're showing proactive support. We're not telling her, "If you don't do this my way, you're out. I won't represent you," unless it's an ethical violation, which I know we have to handle those. That we are being proactive, working with that advocate. And Shelley brought this up earlier. We're patient. I would say we're patient and we're empathetic. Shelley, what do you want to add to that?
Patience goes a long, long way, especially for attorneys, but with advocates as well. I think advocates have the ability to help educate every time they're talking with that client. They have the ability to walk them through the process. They have the support that they need. They can guide them and do everything, and then have somebody leave 7 to 8 times in a relationship. Patience and just knowing that no matter what, that they can return and get that support is extremely important. Trauma-informed representation, especially when advocates and attorneys work together, have made such a difference in so many lives. And the only reason why I know is because Kelly and I did it for many years. And the ability to see the clients several years later and make such a big difference in their life is so profound. The combination of attorneys and advocates working together is successful, and making sure that they get the resources and the legal representation that they need can put them in a position in their lives that makes big, big changes. And so I'm always for trauma-informed representation. And part of that is just knowing that trauma exists in this particular in this case, right? Just making sure that we understand that, and that we don't forget that there are things that are happening.
I think that's great. And I also want to say, my wish for you lawyers out there is that your client thinks you're empathetic, you understand, you care, that you give her options. You're a straight shooter. You tell her the consequences. She gets to choose. And you do it in a way that she doesn't feel boxed in. That if she changes her mind and she wants to dismiss, she can, but she could come back to you and apply for services again. That would be what I would think would be very successful. Next slide. Okay, Shelley, this is your slide.
How might tribal customs traditions affect trauma-informed lawyering? First, if you are unfamiliar with that tribal community, how can you obtain that knowledge? Um, Acknowledging first and foremost that you are in a tribal community, following that respect that for that tribal community, respect for that court, respect for those who are working there, and finding that person, whether it's education on your own or finding an elder or somebody in their historical program, their cultural program, their Indian child welfare, anybody who can give you a little bit of familiarity with their customs and the different things that you might come into, um, how family interacts, what is most important to them in that tribal community, I think is important to find out. Communication barriers, if there are any, to make sure that you have a good representation of somebody in that area who can help you with those. Trust issues are a big barrier for those outside of tribal communities. Understanding that anytime that you're going into that, you are the outsider, and just going in with that type of respect for them, and understanding it's not always going to be on your time level, that things may be a little bit slower, giving that person that enough comfort and time to get to know you before you're asking those hard questions, understanding what that importance is and those kinship rules, um, and understanding that, I think Kelly said it best when attorneys have the ability to win cases and they know exactly what they need, but that might not be the win that the client wants. And so just taking time to understand sometimes those cultural issues mean winning is different than the norm outside of a tribal community. And understanding there are going to be challenges whenever you're going into tribal courts. I think just having that respect goes a long way. And making sure that you respect them enough to try to find out what those customs might be, how those families interact, and what might be the best situation. And getting to know the advocates in those particular communities, because those advocates are going to know those different types of cultural pieces without even having to explain it to them. The advocates are going to be able to help you walk through some of those too. So those are good ways to come through and find out what those tribal customs might be if you're unfamiliar with that tribal community.
And I'll thank you, Shelley. I'm just going to add a couple of mistakes I've made, so maybe you won't make them, because I jumped right into tribal court on a reservation in North Dakota. I was a zealous young lawyer ready to do a great job, and even my interview skills had to be adjusted. I kept interrupting. Some of you might have heard me tell that story before during the whole interview. And the granddaughter asked me, "Do you know why she quit talking?" Because the client quit talking because I was answering everything. And it was perceived that what she had to say wasn't important. So that is a huge issue. Learn the norms. Most likely it's rude to interrupt. Something I had to work on because I have a very um, quick personality and I want to get through the interview, and I only need to know these 5 things for what you told me you wanted. And it's a process. It's a process. You will get better, but you can save yourself from making some of these errors by working with an advocate. And on that kinship rule, Shelley and I were talking about this earlier. It's very important for you to understand the role of each family member. I can remember cases where I didn't understand the kinship. I didn't even know it was important. And it was important in this particular tribal community because the uncles were the one who were supposed to take care of family issues. And the client had gone to get a lawyer. So she went outside of the traditional way of handling the problem. And that had repercussions in their tribal community. So I needed to understand that and adjust my legal representation. And also, I put a young lady on the stand, a tribal young woman, and she was great in the interview. We had the advocate there. She was great when we practiced. And when she got up on the stand, and again, this is in state court, most of the pieces you need to understand for both courts, I'm going to say, whether you're going in state court or tribal court. Put her on the stand, and I kept wanting her to say, I'll do anything the court asked me to keep my daughter. I'll do anything. It's the most important thing in the world for me. And she just kind of froze up on me a little bit. I couldn't get, even with my rephrasing of the question, I couldn't get what I was looking for from her. Thank goodness we won. She got her daughter. But when we went out in the hallway, the aunties told me in their culture, a child was a gift from the creator and they were not to fight over the child. So she was trying to walk that fine line of not fighting, but trying to do what the lawyer's wanting her to do. Shelley, do you have anything to say about that?
About kinship. Um,
Yeah, and how it affects even the questioning. But we have the Anglo system, we're trying to do cross and direct, and how that doesn't necessarily always fit.
it doesn't, and sometimes whenever tribal whenever victims are going through court, no matter what's happening, they don't want to alienate the other family. The other family might actually be an important part of that child's custom and child rearing as well. And so sometimes whenever we're going to court and we're being zealous in our representation, we're also what do you say, making them isolated a little bit because you're pulling them outside and you're taking away from what they normally would do culturally. And so that could have repercussions for her later. I think a lot of times, sometimes our aunties and uncles play a big part in everything. And so if you don't understand that and she's trying to say, well, I want my child to go to my aunt for a few months while I'm getting myself together, and it looks like she's just doesn't want her children, that might not be the case at all. So just kind of understanding how those kind of can interact and impact a case, I think is extremely important. But that alienation of family members is also something that we need to consider because a lot of times we want people to be held accountable, but accountability is something that is different for each of us. And victims may see that differently.
Thank you. And there's something in the chat I'm going to touch on, but I wanted to say this before I forget it. I once did a traditional adoption in tribal court, and I was all gung ho about terminating parental rights of the mother. I had everything I needed to terminate those rights. And it was explained to me because I was representing a couple of elder grandparents who were very patient with me and my zeal, that in their culture, there's no such thing as terminating parental rights. They want to have the adoption go through, but they want the mother's legal rights in place. Nothing can change that in their culture. So I think about that first question, how can you get this knowledge? I'm going to say advocates, I'm going to say elders. I don't, and I don't know, want to get deep into this, but some of these customs and traditions are not meant for outsiders. So the advocate can guide you through it and to help you understand the implications that this might have on the client and your representation. And then I want to say, Chloe says, I think, oh, Chloe, I did this too. I just hate to give you all of my mistakes. My grandmother always taught me, look people in the eye. If you don't look them in the eye, they think you have something to hide. I did that in a tribal community where that was offensive. And somebody had to bring me, one of the elders, and say, don't, that's not appropriate. Don't do that. And every member is going to be different. You may get somebody who looks you right in the eye, but I'm just saying, be aware of these things. Okay. Thank you, Chloe, for bringing that up. Yes, I did that too. So it's been a long road. And I have had many elders teaching me along the way, including Shelley, not that you're an elder, but Shelley has taught me an enormous amount about, even though every tribe is different, some you've got to find a way to get yourself educated on things that are going to affect your representation. Okay, next slide. Shelley, I think this one's yours unless you want me to take it.
No, don't take it from me.
Okay, go ahead.
Tips for working with a client who experienced trauma. To proceed with empathy, ask open-ended questions, focus on physical and emotional safety, ensure accessibility, diminish power imbalance, offer clear explanations, follow the client's lead, and explain the next steps. I think as when we work through our trauma-informed representation and we are talking with clients, it is really important to remember just to have that knowledge of, okay, we have a diminished power of imbalance here. And sometimes whenever we are professionals in a setting, we forget and what we have to offer her, may seem extremely important. We have all of these tools in our toolbox and we have tons of resources and we have all of these things that we come at her all at once with. And we're like, you need to do this and this and this and one, two, and three. And sometimes that can be sometimes it is always overwhelming. And whenever you're talking with somebody who hasn't had the ability to make their own decisions in a very long time, it can be hard for them to even focus on that one particular thing. So always proceeding with care and patience, thinking about all of those things that we've talked about, their cultural pieces. Are they a traditional person? Are they religious? What is going on in that particular family? But especially just offering your explanations as to why you're doing the things or offering the things that you're doing goes a long way. That client, when she's offered certain things, will be able to say, okay, I think I would like to try this instead. And explaining those next steps and saying, hey, this is what is next in this line of filing for a divorce, or this is what you can do. These are all the remedies that can take place. But just actively considering all of those things that we've talked about today, because it makes a big difference whenever you come at it from a traumatic point of view. It makes a difference in the way that you respond to them. It makes a difference in the way that they respond to you. And so I think it's important whenever we're working with victims and clients to recall all of these and how they all come together and how we can, as professionals, be trauma informed in providing these services.
Thank you, Shelley. I want to just add a couple of things for the lawyers. Ask those open-ended questions, although I think it's good for the advocates too. The who, what, how, where, when, why, those kinds of questions. I think this is difficult for lawyers, and we're going to talk about interviewing in a minute. We are so focused on getting what we need, the evidence we need, ask the questions we need to ask to get the client where they're telling us at the moment they want to get. The trauma is not going to allow, in most cases, won't allow the client to give you a linear explanation. It may jump around. So you're going to have to pay very close attention. And then if you could say, stop for a moment and say, this is what I understood you to say, and then repeat and check for understanding. Did you get it right? I think that's super important. And I think that third bullet point, everything you do, every filing you do has a safety implication. So you want to make sure that advocate's knowing when there are going to be filings going out, when subpoenas are going out, if any discoveries going out, because that advocate is busy on the backside doing safety planning. What if he comes after her because he's mad? What if he tries to isolate her in the parking lot because you filed a subpoena? Just be aware of the safety implications every visit, every time. You need to be talking about the safety issues. And that power imbalance, this will be the last one I talk about, but the power imbalance, that's when you go to court in a domestic violence case and that perps attorneys there, all the families there, the perps pastors there, that you understand what that's doing to the client and you console the client. This is going to be okay. This is the way this is going to happen. I prefer to get them ready that that's a possibility before we go into the court, but diminish that power imbalance in that courtroom. Sometimes the judge will do it, but you always be ready to stand up and say, Your Honor, the defendant keeps staring at my client when she's sitting over here. Whatever's happening, where that person's trying to get that power back, be aware. It's like your head's on a swivel. You're trying to take notes. The client you may have given her a legal pad. She's trying to take notes. You have got to be aware of all of these things. All of these things. Next slide. Shelley, is this yours or mine? I can't remember.
I don't know, but I will talk about it a little bit.
Okay,
So
good.
I don't know if you guys have heard, but there are a lot of places who are putting in trauma-informed rooms for meeting with their clients. These rooms are made for those who have traumatic experiences, and they focus on smell, on lighting, on comfort, on ensuring that the surroundings are safe, quiet. They offer snacks, food, fidget toys, different things. But mostly to make sure that whenever a client is coming in, that it's an environment that is um, engaging for them to relax and be able to provide the best information to you. And so I think a trauma-informed representation, whenever you're meeting with them, it's not out in the hallway. It's not right before court. It's not in the parking lot. It's not in a place where there are cubicles and tons of people and things are going on. And sometimes, we don't get to choose where we have our meetings with clients, especially if you're in tribal communities. You have to work with what you have available. But if you have an opportunity to provide representation or a meeting place that can be comforting, you will have better success in getting out the information that you need. The client will relax more and provide more information to you, and they won't be so insecure about who's listening next door. I think that's most important, is that they feel that whatever they're going to share with you can be kept confidential, and that they feel secure enough to provide that information to you. So whenever we're thinking about meeting with a client, even if you can come from behind a desk and sit in front of them as a person, that goes a long way with what they are feeling and how secure they feel about giving you information. Just understanding the way that you're greeting and the way that you are doing that interview process with them is really important. And I think it goes a long way to show them, hey, I'm meeting you where you are, instead of I am outside of this, I'm just here to help you. This mess that you've made. I mean, we don't want to be judgmental whenever we're coming forward and trying to provide services. So anything we can do to make them feel more comfortable, I think, is important.
Thanks, Shelley. We can move to the next slide. I wanted to hit this comment Jerry made about the why question. And Jerry, I think you're right. It's some clients you can, some client, do you have any idea what might have made that happen? What can you explain to me how you were feeling? I think you can rephrase those questions to get at why. And then you may have to make, another interview later. She might be able to expand on it a little bit. yeah, Marlon's saying accessibility, hard of hearing populations, um, disabled, identified, have the print, the fonts where they need to be. I think those are questions you really need to ask up front too. That the advocate could probably help you with that. Shelley already covered conversation can't be overheard. That can be you're having lunch with somebody. Don't talk about these things out in the open. I wanted to flag restrooms can be very dangerous places in the courtroom if other family members of the same gender are headed in. So be aware of that, and to be considerate of how you will take notes. I would hate to think that I think notes are super important. Don't get me wrong, but I think pausing for a minute to listen, and I think explaining to the client why you're taking notes, how you will dress if it's a very formal environment and you have on a suit and you're sitting at a big desk and they're sitting in a little chair right in front of you. That's not really a power balance there. Um, and just being mindful of your meeting spaces. I think you can call ahead and ask the clerk if you're going to need a meeting space in the courtroom. Just take a look at where you're going to be interviewing these clients. I think also letting them choose their seat. They may want the one closest to the door. And if you're doing virtual meetings, to always ask, is this a safe place? Are there other people in the house that might overhear? Those sorts of things. Get all those pieces in place so you can adjust your representation. Next slide. We have a lot of tips for you all when meeting with the client. I just said full attention. Don't forget the humanity in your client. You might ask them how they wish to be referred to. Sometimes they'll go by a nickname. We want to talk about that attorney-client privilege that we've already talked about so much at the beginning, and mandatory reporting, so that they don't think you've pulled one over on them. They know up front that you are required to ask them those questions. And if there's whatever the statute, usually it's about child abuse and neglect, that you're a mandatory reporter, and acknowledge that this is difficult and that they can stop it at any time. They can stop and take a break. You can reschedule for another appointment, letting them set the pace. Letting them set the pace. And that can be hard for busy lawyers, but I think you're going to get a better outcome and the client will have a better experience if you don't push them when they've been activated. Next
Yes,
slide.
and just know the
Okay.
cues of when they've had enough. If it's too much, if it's too hard on them, then know when to stop and say, okay, well then we've done enough for today. Let's come back and do this later. Even if it's later in the day, if you're on a time crunch or whatever, but giving them that break, giving them that opportunity to have just a moment, is important for them, and then they can regroup and come back and try again.
Yes, and that happens many times depending on the severity of the trauma. Next slide. Interview skills, these are going to be, they're blending into the tips, but active listening, not always having your face down in your notepad, open-ended questions that prompt the client to tell the story. And again, I think it's a good practice for lawyers to say, let me tell you what I think I heard, and having them confirm whether that was correct or not. Don't be leading the client, trying to answer the questions. Take time to explain the process and the purpose of the interview. And Shelley was giving us some cues on how to tell if the client becomes activated. You've got to be aware of all of these many, 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 many moving parts during the interview. And they will get easier ordinarily as that trust is being built. Next slide. One more knowledge check.
Oh, how will you
Okay.
provide after the listening interview skills? How will you take notes of client cues? And how will you adjust your approach when client becomes activated?
Any
Interesting.
question, put it in the chat, whatever sticks out at you there. What are you going to change?
How will you provide active listening interview skills? I think one of the most important things is to remember that it's not clinical. And so whenever clients come in and you have this paper before you and you're trying to get all the information out, that can be a very clinical environment and they don't feel like they're being seen. And so having them provide their story without asking questions, I think is goes a long way. You get so much more information from somebody telling you the situation than you do from asking them questions. And so, even as an advocate, remembering, yes, there is certain information you need, but how you get that information from that client is important. And I think the more that you allow them to tell their own story, um, and just give them that moment, you get way more information. I know as an advocate, I do. I get way more information from them just sharing with me some of the history and different things, and just me prompting than me following a list of questions. So I think that is extremely important.
Thanks, Shelley. I also know, Brooke, I love this. I think this might have led to my error in interrupting so much, is slowing down. I'm not a slow moving person, and allow for silence in the meeting. And as long as she needs the silence, let it lie. Don't try to interrupt it. Don't try to rush in and just be empathetic and let her take the time she needs. And that is truly active listening for sure.
It
Also,
is.
go ahead.
I think culturally as well, storytelling is important. So sometimes you're like, why am I listening to this story? But there is a reason. And so just allowing that to, if they are a cultural person, traditional person who is telling you their situation through their story, that's important to them. And to be able to take the time to listen shows them that you have that respect for them. So remembering that is a good thing because even though it's taken time out of the day, um, you will earn their respect and you'll get way more information from them if you do that.
I totally agree, Shelley. Thank you. And uh, is it Josephina says, give them time to think about what they want to say. Let them know I'll be taking notes if you don't mind, and you tell them why you need to take notes. Um, Fabiola says repeating what the client said to make sure you're understanding. I love that. Read the room. And if they look like they are tired, take a break. If they get, I'm telling you, if they get fidgety, if they start wringing their hands. I love the fact you have fidgets. I have one in my hand right now. I think I'm addicted to it. All of those things are great ideas. You're on the right track. It will take, especially, it depends on your personality, but if you're someone who's very uncomfortable in silence, you're going to have to just make yourself sit there until they're ready to move forward. Let's go to the next slide. I think I want to be mindful of everybody's time. Shelley, you want to do the resources, and then I think we can let
Sure.
Marlon wrap us up.
So we have a few resources that we put together from the American Bar Association. Um, and there's also one from Travel Law and Policy Institute. It's a video and the Understanding Historical Trauma and Native Americans. So these resources will be sent to you afterwards as well. So you don't have to like scramble and write them down. Marlon will put them in there. But just a few resources to help expand on some of the things that we've talked about today.
Thank you, thank you. Thank you to our presenters, Kelly and Shelley, today on a very lively discussion. It's always heartwarming to see participation in the chat. If you have any questions, please feel free to email our team. We have a team email address, which is tlaps, TLAPS, as in Sam, at tlpi.org. TLPI stands for the Tribal Law Policy Institute. On your screen, for those who are looking at the live recording now, we have our QR code for our webinar evaluation for today's session. Any and all feedback is greatly appreciated. And just as a friendly reminder, this webinar is part of a three-part legal advocacy series, year 2, brought to you by the Tribal Law and Policy Institute as TTA providers for the legal advocacy assistance for victims, commonly known as LAV, Expanding Legal Services Initiative, ELSI, and grantees and other legal services located on or near tribal communities. This evaluation slide will appear at the end, but let's go ahead and review some of those resources that are specific to TLPI. For our whole team, we have our emails displayed here. The one for today's session is Judge Kelly Stoner, KELLY @tlpi.org. And down in the bottom right-hand corner on the current display screen is our URL for our group project website, which is triballegalservices.org, TRIBALLEGAL as in Sam, ERVICES.org. And if you click on that website, you will be able to see information. Oh, but before that, let's go ahead and just give a reminder. The August 9th webinar will be on victims' rights. You can read the session description there, which was also emailed out on our email blast. If you click on our website, this is the preview to the landing page, triballegalassistance.org. On this website, you can find a section on recordings, which is webinars. You can click on our victim advocacy and also our tribal legal advocacy series. Similarly, if you have a question and are an OVWTA grantee, we do have a technical assistance request form. On top of the menu ribbon on our website, you will see the TTA request form available.
Marlene, I see Chelsea has asked, can you add the link to the chat? She doesn't have a camera available.
Yes. Let me go ahead and I'm going to minimize this as we get ready. Let me go ahead and end the recording so that way it doesn't disrupt the order. Thank you everybody for joining today's session. We'll keep the screen live so that we can get those links to you.
Thanks, everybody.